Hi there, folks. This is Sam Price, and we're here with another episode of Probate Notes. I have with me a very special guest. She's going to tell us a lot about something that is probably widely known about, but little understood about disclosures in real estate. So I want to welcome to the show, Teresa Gorman with Fiduciary Real Estate Services. Hi, Teresa. How are you today?
Hi, I'm doing well. Thank you.
Thank you for being on today. Before we get started, I just want to hear a little bit about you and your background and how you got to where you're at now.
Sure. I started out as a legal secretary, more or less, and really kind of took a very untraditional path to become an attorney. Dropped out of high school, don't have my undergraduate degree, had to do what is called the baby bar. I worked for who I consider my mentor. She had a pretty fantastic education. She was Harvard Law grad with Ruth Ginsburg. They were the only two women in Harvard Law Review.
Wow.
Had a small probate practice. I worked with her. And while doing night law school, she said, I want to retire and offered me her practice. If I had 3 attempts to pass the bar before she retired, I did pass it the first time. And so then I proceeded to take on her practice and was a trust and estate attorney. Through the years, my practice changed from what I took over from her, doing more and more trust litigation, representing a lot of private professional fiduciaries, and did drafting as well. Served as court-appointed attorney in guardian ad litem. About 2018, I had a brilliant young associate who said, I want to quit. And I said, please don't. So we entered into an agreement and he took over the practice and I joined what is our family business, Fiduciary Real Estate Services, which concentrates on the sale of real property with fiduciaries, whether they're professionals or family members. And so I'm a broker associate and have been doing that since.
I think there's some type of disclosure that is specifically designed for exempt sellers on exempt properties. What questionnaire would that be?
So that is called, you'll see a lot of acronyms in the world of California Association of Realtor. Every form is referred to as an acronym, but that is the exempt seller disclosure, otherwise known as the ESD, coincidentally or otherwise. But yeah, that is the disclosure that is filled out by an exempt seller.
What about, and so what, do you know what type of questions that might entail in the exempt seller disclosure?
The exempt seller disclosure has very minimal disclosures. Some of them are asked, was there a death on the property within the last 3 years? There are other questions that it asks. For instance, are you in a commercial zone? Are there any nuisances caused by that commercial zone? And so there are particular questions that are asked, some of which can be answered or found in documents that are routinely provided as part of the escrow process or the sales process.
Because if the exempt seller disclosure asks whether or not there's a death on the property and the seller knows, what is the standard? Knows or should have known? Um,
Yeah, I believe so. So it is always prudent to get a copy of a death certificate and to actually read the death certificate. Because some of these forms, the question is, as reading it from the form itself, within the last 3 years, are you aware of the death of an occupant of the property upon the property? And so if you answer no, but you have a death certificate somewhere sitting around, I would say that you really have a duty to look through those documents and make sure. It's a good idea to review the death certificate, which always has place of death, and to confirm that on the exempt seller disclosure.
because I would think that if we have a trustee of a trust or the personal representative of the decedent's estate, if they're a family member, they're probably going to know whether or not the decedent passed on the property or the settler passed on the property.
Yes, and sometimes, you don't know that. I mean, sometimes it could be a tricky situation where there's 2 spouses and one spouse died and the other, died a couple of years later. So care really needs to be taken. It isn't just a form that you just click through. It's really looking at it. Maybe your trust documents will indicate when someone died, if it's a successor trustee situation, husband died on this date, wife died on this date, but the look back period is 3 years. So you need to kind of be familiar with that and not just assume that it's the most recent death. It could be a tenant or we've had children who have died on the property. So making certain that you ask those questions and that the form is filled out accurately.
Because if we have a fiduciary that is maybe a professional fiduciary, they may not have actual knowledge, but if they look at the death certificate and they see place of death, and if it's the house that's being sold, then they need to disclose that.
Yes, absolutely.
How does someone disclose some condition that they want to disclose?
So there are again, just the kind of rogue forms that everyone, gets and should receive. There is something called a receipt for reports, and that form was just changed this year, actually as well. And so if there's something that historically about the documents, maybe you run across there was an insurance claim if you're going through the property, then you can put those documents on what's called a receipt for report. Very simple. It's just kind of fill in the blanks. Here it is. Here's the date. And the seller has to sign, the seller signs now, and the buyer acknowledges that they have received those documents. So it's kind of meticulously trying to put down each document that you are handing the buyer and making it clear that they have seen those documents. So we try to do that. Um, if we've managed a property, we go through all the maintenance requests, put, as much as we can down to ensure that that information goes to a buyer.
Great. Yeah. And so, do you have to disclose not just the problem, but the result of the problem? Like, do you have to say, oh, well, the roof leaks, but then that means water goes into the house and then that could damage the floor? Or do you just say there may be a roof leak?
If we know so if we're doing the agents have to do a visual inspection of the property, as should everyone. So if we're walking through and there is a spot on the ceiling, we don't say there's an active roof leak because we may not know that, right? Unless there is water on the floor. So it's stain on ceiling, that kind of thing. There's an art and kind of a nuance on what you want to do. You don't have to go out of your way to discover problems. Some people like to go out and get a home inspection report prior, and that home inspection report will kind of list all the things wrong with the property. That's fairly common, especially in Northern California. Or the buyer themselves can do that, but you're not required to do that. And it's a little bit interesting whether it's going to, how that's going to affect the price of the property and whether someone wants to do that or not. Most of our clients do not do a home inspection report to proactively provide it to a buyer.
But the buyer might get that themselves. And then that disclosure, does that supplant what the seller might disclose, or the seller still has an obligation to disclose what they're aware of?
The seller still has an obligation to disclose. There is some supplanting of that. If the seller We had a property recently that had cracking going on. And the issue with it was, we went as far back as we could and found that a structural engineer had said, this looks okay. It's not load bearing. Well, we didn't believe that. So we did get a structural engineer to do a full report, because the problem is you don't even know what kind of a discount to apply to the property. Buying a property with a structural problem is much different than buying one without it. And so because we suspected it and had some indication it was a load-bearing wall, we had another a structural engineer come out, and we provided that to say, hey, before you make your offer, here's the structural report, here's the estimated cost to repair it. It didn't turn out to be a huge deal, maybe a $10,000 deal, but you don't want people making that $10,000 problem saying, oh, it's structural, we're going to take $150,000 deduction. So sometimes you do want to dig a little bit further to protect the seller and the sales price, but you don't have to do that. Merely locating, and noticing the cracks in the wall um, could be enough. But there is a duty to investigate if you notice something. And so where does that duty to investigate stop? If you see it, maybe you do. Everything I like to say, the nice part about not, but I still am an active trust and estate, not active, but I keep my license active, but I don't have to make those tough decisions. The attorneys get to make those to say, hey, attorney, we have this problem. We see it. How far you want to go um, to disclose it and to see what is going on with it.